All right, folks, so I've got something on my mind. I don't want to say the W word because for whatever reason, I keep getting my stuff blocked and banned on social media platforms. I'm gagged. I got a YouTube gag. That right there will get me blocked and banned, but at least this time I kind of deserve it. Let's just say there are certain ongoing conflicts in the world, which I don't intend to touch with a stick, to which you are wondering, well, if you're not going to talk about what you're talking about, what are we doing here? What do I care? Well, that's fair enough. The answer is this. In the world of business and investment, we have the equivalent of the W word, and we call it litigation. So that's what today's episode is all about. Fights, disagreements, disputes, and our legal system. Stand by. Now, I'm going to keep it real here today. I'm going to keep it really real. I'm going to keep it so real that this might even get a little bit uncomfortable here today, but I've got something on my mind, and I think maybe you need to hear about this. So here it comes. Now, there are a couple of different aspects we need to touch on here, but let's just jump right into the big one, money. I told you, we're keeping it real. It doesn't get more real than that. Now, whenever you're in a dispute or there's a dispute brewing on the horizon, you're always going to ask yourself the same thing. Is there enough money on the line to justify what I'm going to have to pay to sue this person? Now, that is the right question to ask. And I would submit that if there's not enough money on the line, or if it's even close, don't do it. Now, whenever it's a little unclear as to whether the amount on the line is worth the cost of the litigation, your instinct is going to be to say, but there's a principle involved here. You know, I get that a lot. It doesn't usually work out well, so let's talk about some of those factors, and I'm going to ask you to think carefully about this principle before you go charging headlong into this litigation. I will admit there may be some occasions where if you don't sue, you're sending a message not only to this particular adversary, but to lots of other potential adversaries that you're soft, that they can get away with whatever. And if you don't make an example, then you're opening the door to more problems. Okay, that does come up sometimes, and if that's the case, fine. Maybe it justifies the lawsuit even where the expense outweighs what you're hoping to recover. Okay, that's possible. For the most part, however, I think there are some particular factors you need to look at. You need to weigh them out carefully, and don't go diving headlong into litigation unless you understand what you're getting yourself into. Here we go. First of all, which court are you in? Okay, there's small claims court. In Florida, there's county court, and then circuit court. So we go in order depending upon the amount of money that's on the line. In California, they just have small claims and superior court, and it all gets bunched together. All right, now, for a small claims court, that is truly designed to keep things quick, easy, and inexpensive. There's a preliminary hearing. The judge is going to send you to mediation. You're going to try and work it out there. If you don't work it out, then you come back, you're going to get a trial date, and that's it. Basically, 2 trips to the courthouse. There's no room for motion practice. What will be, will be. And that's small claims court. So that works pretty well when it comes to controlling the cost of the litigation. However, we're only talking about $8,000, $10,000. It doesn't cover many of the disputes that you have. After that, when we get to county court or superior court and then circuit court in Florida, the door is open to motion practice. So what does that mean? That means that the defendant can file a series of motions to dismiss before they even have to file an answer. That drags things out. It means all the discovery products are available. Not only your interrogatories and your admissions and your request to produce, but, and this is the big one, depositions. Depositions tend to be an all-day affair. They tend to be very expensive. And once you get above small claims court, that comes into play. That's a possibility. I guess what I mean to say is this. Once you get above small claims into what would be a typical range for lawsuits, at least that my firm handles, let's say between $40,000 and $400,000, well, then the training wheels are off The litigation can get protracted, it can get expensive. There's one potential exception that I'll bring up. It is the case, by and large and statistically, that the lower the amount in controversy, the less likely you'll have a jury trial. So that makes some difference. I mean, a jury trial is more of an ordeal, so that tends to make things a little bit more expensive. But in my experience, it almost doesn't matter a whole lot. I think there are some other factors that are more important than the amount at stake in the litigation, which we'll talk about now. Okay, so if you're the defendant in the case, then I guess you don't have a lot of choice. You're being sued. You have to either defend the lawsuit or declare bankruptcy or be uncollectible. Go check out my video on asset protection if you want to know what I mean by being uncollectible. But let me not get sidetracked. That's if you're the defendant. I mean, this video is almost not for you because, you know, you're in it whether you want to be or not. I'm more talking to you, the plaintiff or potential plaintiff. All right, so let's say that you have a good case, which you probably do. I believe you. I believe in your case. However, here's what's going to happen. You have a good case, so the defendant has really two choices. One, settle. That would be great. If they would all do that, that would be great. Here's what they're going to do. Early on, they're going to throw out a lowball offer. You're going to be offended, shocked, and you're going to reject that lowball offer. Once that happens, the defendant goes to plan B, which is delay. Delay, prolong, make the process expensive and painful so that you, the plaintiff, will eventually get frustrated, will get tired of paying attorney's fees, and will go away. So that's the reality of things. I told you I'm going to keep it real here for you. Now, in our US legal system, which is better than any of the other legal systems I've seen and studied, and I have seen and studied a few, but we have something called due process. Now that has a nice ring to it, doesn't it? Due process. Land of the free. Okay, it is a nice thing, but it has an ugly side. In particular, the ugly side is it gives the defendant the ability to drag things out. It gives the defendant lots of opportunities, lots of weapons for slowing down the whole process because that defendant has to be given due process. I'm not trying to be cynical here, but let me give you some examples. Due process gives the defendant the right to take lots of discovery, and that slows things down significantly, and it's a pain. So the defendant is going to send you some interrogatories, 30 to be exact. These are questions that you are required to review and respond to. You have to give a response for each and every question, and some of those questions are going to be really burdensome. You know, they're going to have you going through lots and lots of emails or lots of text messages. You're going to have to go. It's a homework project. You're not going to want to do it. It's going to take you forever to get it done. And that alone is going to drag things out because the case cannot move forward until you respond to those interrogatories. Same thing for a request to produce. They're going to ask you for every scrap of paper, digital or physical, that you've ever touched in your life. And I'm exaggerating, but it's going to feel like it. And it's going to take you time to put all that together and send it to your attorney. And then your attorney has to review all that and put it together in a way that, you know, can be produced to the other side. Drags things out. And don't even get me started about depositions because I mean, I should love them because, you know, it's an all-day affair and I get paid for that. But, you know, from the point of view of the client, I feel sorry for you because these things are painful. They do tend to drag on at least one day. Sometimes they drag on into multiple days. It's very expensive. And it tends to, you know, by the time you actually get the deposition done and over with, you feel like you've you know, accomplished something. But the contents of that deposition tend to lead to more interrogatories and more requests for production. Then there's mediation. Yeah, look, to be fair, it does sometimes get the job done, you know? I don't know what the percentage is, but it's respectable. A decent amount of the time, the mediation, it's long, It's expensive, but if it resolves the case, then it was worth every penny. That said, I do sometimes wonder if maybe these mediators don't use as a technique, in fact, I'm pretty sure they do. They use as a technique, wearing you down. They got you trapped. They keep you there as long as they can, And, after 8, 9, 10 hours, I had a mediation last week that went until 9 p.m. I mean, beyond that, by the time we actually wrote up the settle agreement and all that. I think, it probably works. At some point, you just want to get out of there. It's like a timeshare presentation or something. So you settle the case just to go home. But that's fine. In that case, even if it was a painful experience and expensive, if you got it done, then it was worthwhile. So that's not the worst case scenario. I guess what I'm driving at here is that you're going to ask, how much is this litigation going to cost me? Fair question. I know you have some calculations to make, and that's an important question. And the only honest answer any lawyer can give you is, who knows? Are we in small claims court? Well, probably not, because, we don't handle many of those cases. But what's the amount of controversy? Okay, so that the lower the amount, the more pressure there is on the parties to get the litigation over with and keep it somewhat economical. I can give you some sense there. But I can't give you much more than that, because if the defendant does go into attrition mode, where they're just trying to drag it out and make it long and painful for you, well, then it's going to be more expensive. So it's very hard to answer the question. I cannot give you an honest answer to the question. And I do realize that is entirely unsatisfactory to you. I get that. So let me do this. I've written an article. I know I always do this, pointing to links to my articles, and then there are actually no links down there. But this time I'm going to make sure that there is a link, because I actually wrote and published an article for this very purpose. And what I do in the article is I break down the different stages of a litigation and try to give you some ballpark idea of what you could expect at each stage, always with a caveat that, well, one, you could settle along the way. That'd be good news, right? That cuts the cost of litigation. Or you could have a defendant that really, takes advantage of that due process. But let me give you a sense of what I'm talking about here. And I'm not going to take you through the entire article, but let's just say, the first phase of a lawsuit. What does it take to get your lawsuit off the ground? Okay, well, the complaint has to be drafted. So, there's some question as to how long that takes. It will depend upon the complexity of the complaint. Okay, but nonetheless, I can give you some sort of a ballpark idea. There's going to be a filing fee, which is fairly standard. There's a little bit of variation, but again, I can put you in the ballpark. And then you got to serve the complaint. Okay, you got to serve the defendants. Well, there's a little more play there, because if the defendant is a corporation or any kind of a company, then they have a registered agent. Should be quick and easy. Boom, one trip, bam, you're served. Fine. But if the defendant is some individual who might potentially evade service of process, or in my case, where I deal with a lot of international clients, they might leave the country. Good luck serving that person. Then the process can get much longer and much more expensive. But all right, what I try to do in the article is say, yes, there are outlier contingencies that could affect, the estimate that I'm giving you, but I can at least give you, what would be a typical cost at that stage of the litigation. So stage one, get the case off the ground. Boom. $2,500, $3,000, somewhere in that ballpark, probably. And that's the way I proceed in this article. I try to take you stage by stage, let you know what are the moving parts in that stage. And, you need a number, so I'll give you a number. Always with a caveat, but I'll give you some kind of a number. Well, let me at least give you the different stages of the case, because there's some stuff on the back end that's not in the article and you should probably know about. So, as we discussed, stage one, get the case off the ground. Draft the complaint, serve it. Maybe you include in this stage the motions to dismiss, which again, if you're if your defendant is on the wrong side of the law, knows he, she, or it is on the wrong side of the law, you can expect a series of motions to dismiss. It's very annoying, but they are entitled to do that. All right, so that's stage one, let's call it. Stage two, discovery. So then that's when you get into those different discovery products we were talking about and the depositions, that all happens there. Stage three, let's call that the summary judgment phase. Mediation is probably going to occur somewhere around here as well. But with the summary judgment, you as the plaintiff, and this video is really for plaintiffs, you're going to try and cut this case short with a motion for summary judgment. It's not going to be available in all cases. Do not get your hopes up and feel like every case can be finished off early through a summary judgment. It cannot. I'm not going to get into evidentiary, factual issues and all that, but just, don't expect your attorney to 100% get the case done at summary judgment. In fact, it is getting easier, but it's still hard to finish off a case with summary judgment. But that's phase three. You're gonna want to give it a try, at least, to, even if you don't fully win and finalize the case, you may at least be able to narrow the scope of the case, get a partial summary judgment. And that's worth the time and trouble, because then your trial can be simpler, shorter, less expensive. That brings us then to phase four, which is of course the trial phase. It's hard to overemphasize just how much work and stress and effort goes into a trial. You can't believe much of what you see on TV, but some of those depictions of what law firms go through in a trial that you see on TV, some of that is fairly accurate. Late nights, weekends, when you're in trial, your whole life is about that trial. So it's expensive. I'm kind of talking more about a jury trial than I am a bench trial. Bench trials are generally a one-day affair. I don't know, maybe that's not true. But it's going to be shorter, it's going to be quicker. The judge can get you along much more quickly. Jury trials, there's a lot more involved in that. Now, let's say you get all the way through those first four phases, and let's say you won. Okay, congratulations. Now you have a piece of paper. You have a judgment, which is just a piece of paper. It's not a check. Now you have to go collect on that judgment. I hate to be the bearer of bad news, but the execution phase that follows obtaining a judgment can be almost like its own lawsuit. Now, I guess the good news is this: really everything that you have to do during the execution phase, you're going to get paid for, or your lawyer is going to get paid for. The bad news, again, as usual, is that you as the client have to come out of pocket to fund all this initially, with the hope then of recovering all of it once and if you're able to find some assets. So now we're talking about garnishing bank accounts, liening investment properties. Here in Florida, you can't touch a person's homestead, so you're looking for investment properties. If there are salaries, if the defendant has a salary, that's beautiful. You can garnish that. And then, of course, appeals. That's its own lawsuit. You're probably gonna have to go get an appellate attorney because it's quite specialized and they are particularly expensive. So, due process again. The defendant has a right to appeal. If they want to really, punish you, punish you for bringing a lawsuit against them, then count on an appeal. Oh, yeah, and just to segue off of that last comment, you know how I said at the beginning, you are bringing this lawsuit on principle because people just can't get away with this stuff. I feel you. I understand what you're saying. I don't disagree with you, but the defendant, they feel exactly the same way. Now, maybe I've painted a bit of a negative portrait about a lawsuit. I'm just being real, and it's very important that you go into this litigation experience with your eyes wide open and your pocketbook prepared. Because I find that it's very, very hard to dabble at litigation. that never ends well. Because when you dabble, this is what invariably happens. Okay, you're gonna think to yourself, all right, I read the article, $3,000, $3,500 to get this case off the ground. Let's do this. Because I'm confident that when the defendant gets served with this complaint, that we're gonna settle. I mean, the defendant knows he's wrong. You know, how much money is he gonna be willing to throw at this litigation when he knows he has a bad case? Okay, I understand the logic of that. However, I'm not sure you're fully taking into consideration human nature. The defendant is gonna get that lawsuit and be like, how dare you? I will see you in hell before I pay you one dime. I will mortgage my house. I will spend my child's college money. You know what I mean? They're going down with the ship. So I don't know if this is a bit of a bummer for you guys, but I wanted to let you know. I mean, I think it's important that somebody have this straight talk with you. Is there a moral of the story? Is there a solution, you know, to this situation? Maybe arbitration. You know, the more I do this kind of work, the bigger a fan I am of arbitration. I find that they tend to be more streamlined. You know, there's less wiggle room for the defendants to drag things out. I think that the arbitrators make a concerted effort to keep things moving and keep us on a reasonable time frame. And I've been happy with the judging. You know, I don't find that the arbitrators are poorer adjudicators than what you find at the courthouse. So, you know, maybe that's a solution. I write arbitration clauses into all my contracts now. At the end of the day, human nature is what it is. There are going to be disputes, even with brilliant contract writing. Well, there you go, folks. I promise you a more uplifting video next week, but I thought it was important that you hear some of this, you know, a little bit of a reality check maybe. Don't go half-cocked into litigation. If you're gonna sue somebody, then sue somebody. Sue the hell out of them. But don't get angry with your attorney when the lawsuit takes longer and becomes more expensive than you would like, because that is very likely to happen. But, you know, we can't change the Constitution. These defendants have the due process rights that they have, and ultimately there's a limit to what we can do about that. But there you have it, guys. I will see you next time around.